Good morning, everyone. We'll acknowledge that today is the first day for our new clerk, Grant Butler, to have opened court. I'm assuming his tape survived the sounding of the gavel. Welcome to your new role. Our first case this morning is Providence Volunteer Fire Department, Inc. versus the town of Weddington et al. And we will hear from the appellant.
May it please the court, good morning. Good morning, Chief Justice Newby and the associate members of this court. My name is Christopher Duggan from the Duggan Law Firm, Union County Bar, Monroe, North Carolina, and I have the honor and privilege to represent Providence Volunteer Fire Department in this litigation before this honorable court. Before I get going, I'd ask for a reservation of approximately 10 minutes, if I may, for a rebuttal. Your Honors, we're asking this court to reverse the Court of Appeals decision and reinstate the learned opinion of Judge Daniel Keenert of the trial court. I'd like to correct something in my brief, if I may, first before we get going. I had stated that the standard of review for this personal jurisdiction issue was a deference to the trial court. I believe after my research and preparation for today, I believe it is a de novo review. The case, White versus True, which sets that out, discusses de novo review with regard to sovereign immunity. Because we're talking about governmental immunity on this basis, I'd invite the court to extend that holding to hold for governmental immunity as well as the sovereign immunity. This case also involves two different defendants with two different issues. The issues before this court with regard to the defendant town is governmental immunity. The issue before the court with regard to the defendant mayor is legislative immunity. We would offer to this court, no matter how this court looks at this case, it is clear that the defendant town and defendant Dieter engaged in fraud, fraudulently induced my client to transfer its long-held property to the town so that it may hold that property and transfer it to another volunteer fire department. The town didn't need this property to have fire service in the town, but it needed this property in order to come to fruition its desire to transfer the service to another fire company. Court of Appeals erred in several ways. The first of which is they didn't do a fact-intensive investigation as this court has instructed it through the estate of Williams. What the Court of Appeals did is it used a statute which I think is wholly inapplicable to this matter. The statute used was Chapter 69, Article 3A, Rural Fire Protection Districts. Weddington is not a rural fire protection district. Providence Volunteer Fire Department is not a rural fire protection district. And we need to go no further than the first paragraph for a sentence of 69.25.1 or -25.1. Upon the petition of 35% of the resident freeholders living in an area lying outside the corporate limits of a town or a city. This matter involves a fire company located inside the corporate town limits. 69 is not applicable. There was not an election had, a special election called for by the County Board of Commissioners as is required by 69. The statute is inapplicable. What I believe the Court of Appeals did is look at the statute and says, here is where the legislature discusses fire departments. Here is where we can hold that this fire service is a governmental function. And yes, as a state of Williams has pointed out, something might be considered over its life to be a governmental function, but that's changed or can change. It's a fluid situation. That is why we're requiring a fact-intensive investigation. And when you do that fact-intensive investigation, you're going to see a number of...
Mr. Duggan, before you move on there, let me make sure I understand you. You are not contending, are you, that a municipality doesn't have the authority to enter into a contract for fire suppression service with a volunteer fire department, are you?
That is not what I'm contending, Your Honor.
Okay, because I saw the in-depth discussion of these statutes in your brief, and I was trying to figure out exactly where you were going with that. If you were not contending that a municipality doesn't have the authority to contract with a volunteer fire department for fire suppression service, why should we view these? What purpose do these statutes serve, at least in your understanding of what the appropriate governmental immunity analysis is?
I don't believe that they serve any role in this particular...
In your view, they're irrelevant then?
For this case, yes, Your Honor. And the reason why I say that, Justice Ervin, is when you look at the various phases in the relationship between the parties, and the court in the estate of Williams has set out, look at those phases. Here, the basis of the plaintiff's fraud complaints arise from the transfer and sale and leaseback of my client's property. That's a specific activity and a specific phase in the long-term relationship.
So if you divide every governmental activity as you are proposing that we do, does acceptance of your argument mean that any contract that a local government chooses to enter into for the purpose of obtaining an asset for use in providing a governmental service therefore becomes proprietary?
I would, Your Honor, in this specific case, and if you're
well, I mean, but I'm trying to talk more generally about what would be the implication of the holding that you're asking us to make in this case. Are you saying, in effect, that any time that a municipality enters into a contract for the purpose of providing a governmental service, the process of entering into that contract and administering that contract, therefore, is a proprietary activity not subject to governmental immunity?
It depends on what portion of that contract we're discussing, Your Honor. Normally or generally, when you enter into a contract, a municipality or a governmental agency will waive that immunity simply by entering into that contract. That comes from Can-Am.
And as I understand it, you still have a viable contract claim pending in the trial court.
We do, Your Honor. That claim, and actually, I understand that the trial court discussed it, and I understand that the Court of Appeals has discussed it, but that has never been part of any motion before any court. That breach of contract claim is still alive and will still continue.
So even if we were to rule against you in this case, you still have a right to proceed with your breach of contract claim in the trial court?
That is correct. However, we believe that the remedy that's provided by that contract is insufficient to make my client whole at the end of the day. That's why we are pursuing both the fraud claim as well as the breach of contract. And again, it's dealing specifically with the transfer of that property. The town of Weddington decided to create their own district, fire district, in 2013. They entered into the interlocal agreement, which was an improperly styled agreement, and they entered into a fire suppression agreement. They waited almost a year to enter into that contract to transfer that property over to the town. And during that time, that's when the fraud was taking place. Everybody had an expectation going in to this transfer of the property. My clients had the expectation that they were going to have a 10-year fire service agreement. However, you will see from the pleadings where I have alleged numerous facts to demonstrate that while they were moving towards the transfer of the property, the mayor and the town engaged in fraud.
And I guess I'm going to stop asking you questions a second and let you get on to your argument, but you've got on the other one that I was going to ask you. Is it your contention that the availability or non-availability of a governmental immunity defense depends upon whether there is a valid claim of liability?
And if I can ask Your Honor to repeat that.
I'll give it a shot. I mean, you've repeatedly argued that one of the reasons that you should not be barred, your claim shouldn't be barred on the grounds of governmental immunity is because that you have successfully alleged various fraudulent activities. I had always understood immunity to be something that prohibited a claim regardless of whether it was valid or not. are you contending that it makes a difference for purposes of governmental immunity whether the claim that is being alleged is or is not valid?
I believe that to best answer that question, Your Honor, I think what the absolute immunity provision falls under the sovereign immunity claim. So when a state is being sued, a state agency or a state representative is being sued. Here, because it's a governmental agency, a municipality or a city, there is exceptions to that governmental immunity as set out. And those exceptions include the liability of the fraud.
Well, maybe I misunderstand immunity law at a fairly basic level, but I had understood in effect that if a claim was barred by immunity, it was barred, and it didn't matter whether the claim was valid or not valid because the purpose of the immunity was to prevent the entity from having to even defend against it. Why does it make any difference whether you have alleged a valid claim of fraud or not in terms of determining whether governmental immunity applies because we have a governmental function as compared to whether governmental immunity doesn't apply because we're talking about a proprietary function?
Well, and I think that's what Your Honor, the last statement of Your Honor points that out. Here is the proprietary function. That's what we're alleging, is that the town is engaged in a proprietary function. So governmental immunity would not apply when the town is engaged in a proprietary activity. If the town is engaged in a situation that has nothing to do with a governmental function, then yes, the town does not have that governmental immunity available to it because it's not a governmental act. Here, the transfer of the property, as set out by the estate of Williams and the factors to be considered, transfer of property can be done both publicly and privately. It can be between parties, third parties, between governmental agencies and not governmental agencies. This is not a situation where only the government holds that avenue to enter into a contract for transfer of property. That's what we're specifically on. And the Court of Appeals acknowledged that we had alleged that the act in front of it was a proprietary act and that the transfer of the property was the proprietary act. And that's what we're alleging. We're not actually alleging that fire service is not a governmental act. I think that's pretty standard that providing fire service, if you are a municipality and you have a municipal fire company, that is a governmental act.
But you do seem to be arguing that a contract to obtain an asset that would be useful in providing fire suppression service is a proprietary activity. It might be different if it was absolutely necessary to obtain that asset, but if it was a discretionary determination as to whether to use that asset or some other asset, that, in your view, then would be a proprietary function, is the way I'm understanding your argument.
That's correct, Your Honor.
Okay.
That's correct.
How do we reconcile your, I'm sorry, Justice Hudson.
Go ahead.
May I?
You go ahead.
All right, thank you. I'll make it quick. How do we reconcile your position with the Mike versus City of Gastonia case, if I'm pronouncing the Mike party correctly, that downtown revitalization case out of Gastonia, in which we decided relatively recently that the proprietary aspect of the government's function coupled with the immunity aspect makes it a case-by-case basis. It sounds like you would have us to have a broader approach to that and say that the immunity would not apply. How does your position reconcile with our holding in that case?
Your Honors, that case is different from the case at bar. There is a statute there, the Revitalization Statute, that talks about revitalizing blighted neighborhoods. And that statute specifically references that as part of the governmental function. Here, we're missing that statute. We don't have the statute that says that the transfer of this property for a fire service where you might need the property or it could be useful, that is a governmental function. In the Mike case, you have that. The statute sets it out, that this is a governmental function. In addition, that involved an injury to a third party who was not a part of that lease. Here we have an individual, or the fire department, which is a part of that contract for the transfer and for the lease back. And that's what the difference between Mike is in this case, Your Honor.
Would we be doing something different in this case at bar here, or are you asking us to extend or otherwise differentiate between this case and Mike?
At the most, I would ask is this court differentiate the difference between this case and Mike. And the reason for it is this case again, there's a statutory scheme that was in place, the Revitalization Statutory Scheme, that allowed for the court to make that determination that it was a governmental function because the statute said it was. It was part of their governmental function to renew these blighted areas. In this case, we're just dealing with the contract for transfer of property.
Justice Hudson, thank you.
I was just going to ask you about, don't we look at the entire overall purpose of the agreement, that that the purpose of the purchase was ultimately to provide fire protection services, wasn't it?
Well, and if the court looks to its decision in the estate of Williams, it says we shouldn't look just to the overall outcome of it. We got to look to the various phases along the way. And if we look to the Sandy Creek decision, the second Sandy Creek decision, you will see that in play. That case involved the construction of a sewer facility. At the end of the day, there was going to be a sewer facility built. However, along the way, there are contracts with contractors and other things that the court says you got to look at the various phases along the way, not just the overall goal that it's a governmental function.
Well, I didn't see that we have that particular multiple phases here. You have a contract, couple of contracts, one of which is to provide fire protection services. And I heard you say that they might or might not use the property for fire protection services. Was there any indication in the record that they were going to use it for anything other than a firehouse?
No, forgive me if I led to that misunderstanding. No, that what I was trying to reference is that the firehouse was not necessary to provide that fire service. They could have contracted with my folks to operate out of that firehouse. They could have asked another fire company to operate under a different firehouse. What they did is they needed that fire or that property in order to effectuate their intention to terminate the contracts fraudulently and transfer that property to a rival fire company.
So do we look at the contracts and the overall agreement that they entered into here, or what they might have done otherwise?
I believe you just looked to the contracts that are entered into here. You have the interlocal agreement, which was the overall
Right.
agreement. You have the fire suppression agreement, which was the 10 years fire suppression, a renewal of 5, how much you're going to get on your initial funding. Then you have this last piece of the puzzle, which is the transfer of this property. That we will renovate this property at a cost of $935,000, and in the end, we obtain a valuable piece of property that is now, post-construction, worth $1.596 million. That's a nice benefit for the town to have on its books. That's a significant increase in value for its investment. If the town invests $935,000 and gets a $1.56 million piece of property, that's a significant pecuniary gain. Unless Your Honor has another question?
Well, I'm still a little unclear about the basis of the distinction you were trying to draw in response to Justice Morgan's question about the Mink case, because the broader principle that we stated there was that you sort of look at the overall purpose about whether the agreement is governmental, is designed to promote a governmental purpose. And there we thought there was, even though there's a statute that you pointed to. How do you distinguish that kind of analysis from what we're supposed to do here?
Well, simply stated, there is no statute in our case that points to that. And that's the gravement of the complaint, is there is no statute that's issued by the legislature that says contracting with the fire department to take its property, lease it back, is a governmental function. I'm unaware of any statute that says you, municipality, purchase of a piece of property, that is now a governmental function.
And is it your argument that the statute needs to be down to that level of granularity before there is a valid claim of governmental immunity?
I don't think it has to get down to that level. I think the level is there. The problem is there's a hole in the statutes, and that's for the legislature to fill. Simply because there's a hole in the legislative statutes that doesn't recognize a fire department, which has become what fire departments are now. They're called voluntary fire departments, but they're truly not really voluntary. These voluntary firemen go from department to department, make up their weeks. They work at this department here for 2 days, this department here for a day. They have a somewhat of a volunteer base, and you'll find more of a volunteer in the rural communities, but they have a volunteer base. I believe what the statutes need to do is recognize that this is not a municipal, so it's not run by the town of Weddington. The town of Weddington doesn't pay the firemen directly. This is a third-party vendor, if you look at it that way. It's a third-party vendor to provide the services that they're looking for. That's all they are. Answer your question? And as I'm quickly winding down on my clock, I'd like to at least move over to the defendant mayor in the legislative immunity claim. Again, this is renewed de novo. This claim, the court jumped to the fact that he might have said something before election, and then the town council, without him, voted to terminate. Again, the complaint is replete with factual allegations that state the fraudulent actions by the mayor after he took office, between the time that he took office and the time of the transfer of the property. The mayor instructed the town attorney to construct a decision tree that would lead to the termination of the fire department, but didn't publicize it to anybody, didn't publicize it to its other members of the council. The mayor instructed the town attorney to go investigate before the property's transferred. Here's where the intent is, and we specifically state it. Go and see what our defenses are for breaches of contract. What are our defenses for immunity? That's what the mayor and the council for the town was looking at. It's a clear intent the whole way that they did not intend to honor that agreement. This is big government gone awry. We're going to get that piece of property, and we're going to do what we want with you and put a 60-plus year fire service company out of business, out of existence. And that's what they did. With regard to the mayor, he was acting in his individual capacity at all times, outside the scope of setting the agenda, putting something on the agenda. What he did in instructing the attorney to take these actions was outside the scope of his authority as a mayor, outside the statutory scope of his authority as the mayor.
Because he acted fraudulently?
That's correct, Your Honor. He acted outside.
That's the fact that takes it outside his area of protection?
Well, he can add things to the agenda. That's within his authority. That mayor's authorities are limited, as you know. So his authority is to run the meetings, put things on the agenda, those types of things. Not to direct counsel as to what to do and how to terminate this contract, or to go investigate ways to terminate this contract. And that's what the mayor did. And we believe it, again, at this early stage, this case has been going on, was filed originally in 2015. We have had very limited discovery. We have been nothing but motion practice. We've been up to the Court of Appeals twice, now before Your Honors on this matter. Your Honors, this is a case that is, if you look at all of the factors and all of the facts that are set out in the complaint, demonstrate a fraudulent act and intention and a plan to get that piece of property so they can terminate the agreements, have that site, which is central in the town, have that site to give it to another fire company. And that's what they did. They worked in that avenue to deprive my clients of their property without just compensation and give it to another rival fire company. Unless there's some other questions, I'd like to reserve some of my time for the rebuttal, if I may. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court. My name is Andy Santinello, the I is silent, of the Mecklenburg County Bar, law firm of Pope, Awood, Sweeney, and Santinello. I represent the town of Weddington. I intend to speak for approximately 15 minutes on behalf of the town, and then I will yield to my colleague, Mr. Bailey, who will speak on behalf of the mayor. I'm going to jump right in because I believe the crux of the dispute between Mr. Duggan and the plaintiff versus the town is how we view the underlying activity that is the subject of the fraud claims. There was, in the original complaint, in the amended complaint, a fraud in the inducement and a general fraud allegation against the town. Judge Keener at the trial court level combined those two for purposes of analysis, and I think that's appropriate. Keep it simple as much as we can for this court. It is, as I understand the argument of Mr. Duggan expressed here and in his brief, it is the position of the Providence Volunteer Fire Department that the underlying act here was the purchase of the land, that his clients were duped into giving up title to their long-held fire station to the town, and that the town did not need to purchase that property in order to provide fire protection to its citizens. The town's position to the contrary is that we look not only at just the single act of purchasing that property, but we look at the entire global agreement between the two parties here to see what it was, what was the purpose of the town. And I think the operative question is, why did the town purchase that fire station? And I think the answer is clearly in the record that was before the trial court, the Court of Appeals, and this court. In his new brief to this court, Mr. Duggan attached the 3 written contracts that constitute the overall agreement between the parties here. In order of chronology, they are the fire suppression agreement. There is an interlocal agreement, which, whether it's misnamed or not, involves the actual transfer of the property itself. And then there is the third, a lease-back agreement, where the town agreed to lease the fire station back to Providence for its use for, I believe, $1 a year, if I'm remembering correctly. Those 3 contracts are bargained for exchanges. It is not a unilateral, self-serving statement of the town. It is an agreement the parties reached at the time, back in 2013, as to why they were entering into this agreement. If we turn to the very first page of the fire suppression agreement, we will see very clearly set forth why the town entered into this agreement and why they purchased the property. 1, the town wanted to provide fire protection service to its citizens. 2, it wanted the Providence Volunteer Fire Department to do so. 3, it recognized that it wanted to secure the long-term stability of the Providence Volunteer Fire Department. 4, the station in question was in need of immediate repairs. 5, that Providence was going to have to undertake debt to make those repairs so they could be serviceable to provide that fire service. 6, the town was willing to undertake to help fund those repairs, and the parties agreed as part of their security for the town willing to do so that the fire department would sell the station to the town. If we flip a couple pages later into that fire suppression agreement to the penalty clauses of that contract, it states that there is a bargain for liquidated damages clause, that if the town were to breach this contract, there is a $750,000 liquid damages provision that is specifically stated to compensate compensate the fire department for loss of its real property, i.e. the fire station. If we read all
and again,
Yes,
just
sir.
to make sure that everybody's on the same page here, because I'm finding very few areas of agreement, there's no question but that the contract claim that the town asserted in its original pleading is still pending in the trial court and is still viable at this point.
You're correct, Justice.
So that regardless of what we do here, the fire department will have the right to seek to recover damages depending on how they're determined, whether liquidated or otherwise under the contract.
You are correct, Your Honor. Regardless of what happens here today, this case will go forward in the trial court. The plaintiff will have their opportunity to prove that the town was incorrect and improperly breached the agreement. As the Court of Appeals pointed out, we are not dealing with the contract. We are dealing just with the tort
We're dealing
claim.
with tort claim.
With the fraud tort claims. Yes, sir.
So, go ahead.
No, please.
So you've listed various reasons that are stated explicitly in the contract. What if those are a facade? Isn't that the essence of the tort complaint? That while there may have been these statements that were made in a contract, the true reason was very different than what was stated. Isn't that what's being claimed here?
Yes, Your Honor, and I think the distinction is that we are talking about sovereign immunity for the fraud claims, that there may very well, if we assume for purposes of argument that the town did commit fraud, is that claim a claim that is subject to sovereign immunity? As I have been,
You mean governmental?
I'm sorry, yes, governmental immunity, because we were talking about a municipality. Is whether or not that claim is subject to the immunity. I have been trying to differentiate, because I think the dispute between us is whether or not we're talking about a proprietary versus a governmental act. But assuming that fraud did occur here, I have cited in the brief the Herring versus Winston-Salem Forsyth County Board of Education Court of Appeals decision, which stands for the proposition that sovereign immunity or governmental immunity on a fraud claim is subject to that immunity. So that we're, as Justice Servant pointed out, the contract claim will still be there. This is whether or not they can pursue that fraud claim. And the governmental immunity is not only an immunity from judgment, it is immunity from suit. So I think that is the fine distinction that we're dealing with here.
But aren't we having to also address the flip side of one of Justice Irvin's prior questions to your colleague and his response, which had to do with is fraud either in the inducement or fraud surrounding the contract itself, is that always exempt from governmental immunity? That would be one argument. The other argument is no, municipalities can fraudulently negotiate any kind of contract, and they're always going to be immune. Is that your position?
Your Honor, my position is separating the two. They always have the contract claim. That's not subject to the immunity. But a fraud claim will always be subject to immunity if it's a governmental act and the municipality has not waived its immunity. Yes, that's my position.
So let's say that they were going to buy a fire truck, but they knew that for whatever reasons that they were not going to pay the price that they agreed upon. The city knew right from the start. But just because it's a fire truck, then they would not be liable. But if it's a copying machine, and they fraudulently entered into a contract to buy a copying machine, then they could be liable. Is that, we look at a fire truck versus a copying machine?
I think Your Honor is showing the fine distinction here. A copier machine is much easier. I don't think there would be any logical argument that a copier machine might be a governmental act. It's a
Well, let's say that it's used exclusively for the fire department.
It's possible, Your Honor. I think if I may jump to your analogy of a fire truck, I do not disagree with my opposing counsel that this immunity question is a very highly fact-specific argument, that if we have to look at the individual facts of each case. If we use your copier example, if it's going to be a copier that's just used in general to copy water bills for the general public, I don't think that would could possibly be an immune act. If it's only going to be for the fire department, there may be an argument that is part of the fire suppression. And I think in your analogy, there would always be a contract underlying those transactions. I mean, a copier is an expensive piece of equipment. A fire truck is an incredibly expensive piece of equipment. So I think there would always be that contract that could claim that could be breached in parallel. But what we're dealing with, I think, here with this court, as Your Honor points out, the fine distinction is, where do we draw that line between a governmental act? What is the overall purpose here? And as Mr. Duggan has argued, the overall purpose is purely just to buy the land, and that's proprietary, not governmental. I'm suggesting that we're looking at the total picture. If we look at all these facts, the best evidence being the language of those agreements, not just the fire suppression agreement, but the language written into the other two that directly refer back to the fire suppression agreement, stating that the whole purpose of this overall arrangement is to provide fire protection services for the people of Weddington.
Well, help me understand the good public policy reason behind municipalities. You can commit fraud with impunity if it has to do with fire trucks or fire anything. But if it doesn't have to do, I mean, why should there be this distinction? Why shouldn't the government always have the responsibility of acting in good faith and fair dealing when it enters into a contract?
Your Honor, the role of a government entity is always going to be subject to criticism, no matter what decision they make, whether it's a legislature, whether it's a city council. There will always be those that will claim that they were wronged by a decision, even if it's just one person. If we shadow or darken the possibility that every decision made by any legislative body is always going to be subject to potentially not only some type of claim, but a fraud claim, I think that would chill the overall ability of governmental people willing to serve on government and the ability of legislative bodies such as town councils to make decisions freely as they see fit for the best interest of their citizens. Again, the plaintiff here in this particular case will not be without remedy if this court upholds the decision of the Court of Appeals. They will have their opportunity, whether it's through a liquidated damages clause or through a full breach of contract claim, to recover for their damages. And they will, a jury of Union County will get a chance to pass on whether the town council of Weddington made appropriate decision or acted in bad faith in breaching this contract.
So my question is about what facts we are to consider. We've established that this immunity question is a highly individualized, fact-specific question, and here the issue is whether this was a governmental or proprietary function. In making that determination, because this is on a motion to dismiss, aren't we supposed to look to the allegations, base that decision on the allegations as they are in the complaint?
Yes, ma'am, but also since this was filed on a 12B1 and 12B2, some additional materials can come before the court, including the affidavits of the town administrator and the town finance officer, and I'll come to those here in a second. But my position to the court is that there is sufficient information in this record to make a determination by primarily looking at those terms and clauses of those three agreements to determine what was the purpose of entering into this agreement. Why did the town seek to purchase the property? What was that part of?
Right, but to the extent there are allegations in the complaint about what the purpose was, and that in fact it was a fraudulent purpose, aren't we required to make this determination based on those facts?
Yes, ma'am, I would agree, but again, going back to the purpose of the immunity defense in and of itself is an immunity from suit, not just from judgment. That is the role of first the trial court and then the appellate courts, if it reaches this stage, to review the allegations of the complaint, the evidence in the record, and determine whether or not the immunity applies, because if not, the town ultimately loses that immunity and it's a meaningless benefit.
Right, but I understand that's the function of immunity, but here we're trying to decide as a threshold question whether or not this was a governmental function or a proprietary function.
Yes, ma'am. Forgive me if I'm not understanding your question. I guess my point is that I believe there is sufficient information in the record to make a determination, and that it is appropriate for you all to make that determination.
Let me ask you the same question I asked Mr. Duggan in a different context. Does the extent to which the town engaged in tortious conduct control whether we have a governmental or a proprietary function? In other words, is the validity of the claim that the fire department seeks to bring against the town relevant to the determination of whether we have a governmental or a proprietary function?
My position, sir, is no. It doesn't matter the level of agree, at least for the town's point of view. That may be a different argument as it comes to the mayor.
Right, and we'll discuss that with Mr. Bailey when we get there.
Yes, sir. But as to the town's point of view, I believe the degree of alleged fraud is irrelevant. I think we're just looking at the nature of the tort.
And so really the decision, at least as I've always understood it, the extent to which the fact that the town, if it is a fact, may have engaged in wrongful conduct really involves not a question of do we have governmental immunity or governmental or proprietary purposes, but rather whether we have governmental immunity at all.
Yes, sir.
And so if we're going to start saying in effect that we've alleged wrongful conduct, we don't like that, therefore we're going to allow the claim to proceed, that's really inconsistent with the entire concept of governmental immunity, isn't it?
Yes, sir. As I think I was, and maybe not very articulately, trying to represent to Justice Earls, I believe that the whole benefit of the immunity, if it exists, the benefit is to prevent not only judgment but suit itself, to provide that protection. I see I have dipped below the 15-minute mark. In fairness, Mr. Bailey, unless there's any additional questions from the court, I will yield to Mr. Bailey.
Thank you, Counselor.
Thank you.
Mr. Chief Justice, Honorable Associate Justices, may it please the court. My name is Frederick Bailey of the Craven County Bar, and I am here on behalf of the former mayor, Mr. William Dieter. Plaintiff's allegations of fraud, as asserted against the former mayor, at their core are an attempt to hold an elected public official liable in his individual capacity for a failure to adhere to a campaign promise.
I didn't hear the last part, for a failure
to adhere to a campaign promise. I apologize, Your Honor. The chilling effect such precedent would have on our local governments would not only serve to stifle debate, but forestall state or federal municipal legislation. This would simply be unsustainable. In response, Mr. Dieter requests that this court consider the doctrine of legislative immunity. That doctrine, which was first addressed by the North Carolina Court of Appeals in 1996 in the case of Vereen v. Holden, has been consistently reaffirmed since then.
Now, it's always important in these cases to keep our categories straight, I think. In your understanding, is legislative immunity synonymous with public official immunity, or are the two different? And if there's a difference, what is it?
No, Your Honor, they are substantially different. Legislative immunity is...
So that the rules governing public official immunity don't have any bearing on whether there's legislative immunity or not?
No, Your Honor. Now, I would note that there would be a situation with regards to the mayor if he was acting in an executive capacity as opposed to a legislative capacity, then public official immunity would be appropriate. But when we're talking about legislative acts and performing conduct within his legislative capacity, then the doctrine of legislative immunity would
At least
apply.
as I understood the Court of Appeals decision, it was on the basis of legislative immunity only and didn't go to other forms of immunity that might be available to the mayor.
That is correct, Your Honor. That's correct. And we believe that it is appropriate for this court to recognize the doctrine because not only is it consistent with our lower court's common law, but it is also consistent with several general statutes that have been enacted since that specifically invoke the provisions of legislative immunity. And it is also consistent with this court's holding in Steelman versus City of New Bern. It's a 1971 case. We further submit that this court should adopt the Fourth Circuit test as it was applied in the Vereen case, again, the original case in which it was adopted by the Fourth Circuit, or strike that, the North Carolina Court of Appeals, as it sufficiently states the doctrine's purpose and is a clearly workable standard. And if that standard and if that test is applied to this case, we respectfully submit that the former mayor is entitled to a dismissal under the doctrine of legislative immunity.
Would the legislative immunity apply, in your view, to comments that were made and positions that were taken by the mayor when he was a candidate for office?
No, Your Honor. I do not believe that legislative immunity would extend to activities that occurred while he was a candidate, as the actual statements themselves would be non-legislative in nature.
So how would we differentiate between the two in light of your colleague on the other side's position on this concerning the mayor's culpability?
That's an excellent question, Justice Morgan. First, I would note that the purpose of legislative immunity regarding culpability is to eliminate any inquiry into the individual officer's motive or intent. To allow legislative immunity to exist as a doctrine, but to be able to pierce that by making allegations with regards to the intent or the motive of the individual officer would essentially swallow the protections provided by immunity. While not specifically articulated in our Constitution, there has been multiple general statutes that have relied upon, enacted, and it otherwise heavily implied the existence of legislative immunity. The first, we would respectfully direct this court's attention to 120-9, which was enacted in 1787, predates the federal Constitution, and specifically provides our state legislators with a testimonial privilege. Importantly, when this statute is compared to Article 5, Section 5 of the Articles of Confederation, the language of the two, while not identical, they certainly rhyme. And the relevance here that we would respectfully submit is that Article 5, Section 5 is the precursor to the current speech and debate clause of the federal Constitution, which serves as the springboard for federal legislative immunity. We believe that there's certain parallels there that are worth taking note of. Additionally, as highlighted in our brief, some of North Carolina's more recent legislative enactments expressly reference the doctrine. The three referenced in our new brief are 1-72.2, 120-32.6, and 120-132. Each of these statutes presume and rely upon legislative immunity as an established legal doctrine. They go so far as to actually acknowledge and invoke the existence of the doctrine.
Let me ask you just a few basic questions.
Yes, Your Honor.
One, if the mayor had not been elected, then he would not have been in a position to do any of the things that are alleged that he did, correct?
Correct.
And even after he was elected, whatever he did, he wasn't acting as an individual, he was acting as a mayor, whether he's trying to influence the alleged fraudulent activity or whatever it may have been. As an individual, he had no authority to do anything, correct?
That's correct, Your Honor. His actions as mayor would have either been executive or, as the allegation, or with regards to the allegations in the amended complaint, all of those would submit legislative in nature.
And so his only authority as it impacted this particular contract or the alleged breach, the fraud that was alleged, all of it was in his capacity as an elected official to be able to influence whatever the town may have done with regard to the contract.
That's correct, Your Honor. His actions with regards to the specific fraud, which this court articulated in Hamilton v. Hamilton, the fraud is not in the original statement made, but in the subsequent inconsistent position taken. And it's because that subsequent inconsistent position is where the injury occurs. And in making that holding, I would respectfully submit that this court primarily focused on where the injury in the fraud originated from. And in this particular case, as the Court of Appeals pointed out, the injury was the termination of the fire suppression contract. And that occurred during a town meeting that was called by Mayor Dieter, and during a vote that was called also by Mayor Dieter, but was approved of by the council members. And we would respectfully submit that because of where the injury occurred and during the instance in which it occurred, that it was appropriately in a legislative act.
I know it would never occur in reality, but if a politician were to make a promise and then once they got into office, they didn't fulfill it, is that in essence what's being argued here, that somehow that there's some culpability based on that?
Your Honor, I would not presume to make a statement on behalf of opposing counsel or state his position, but that is certainly the point of view of the mayor at this point in time. And the concern that we have is if we allowed this particular type of claim to proceed, it would open the floodgates of litigation at all levels of the state.
Let me get a little bit into the details of when legislative immunity does and doesn't exist. I think I understand why. I mean, as I understand it, the two components of it are, first, legislative activity. I think you've talked with the Chief Justice about that a little bit. And then the second is that there was no unlawful activity. If I understand your colleague's brief, he argues, in effect, well, we have that because he committed fraud. What does unlawful activity for purposes of legislative immunity mean as you understand it?
I would respectfully submit that that would mean that that would be a criminal act as opposed to an act that would expose an individual to civil liability.
Well, wait a minute, though. A criminal act exposes you to criminal liability. I think you just said civil liability.
I apologize, Your Honor.
And so I'm trying to, again, the categorization is important here, and I'm trying to stay in the correct category.
That's correct, Your Honor, and I apologize for that. I would note that an illegal act for the purposes of the test would be a criminal act.
Is there a case that says that you can cite me?
No, Your Honor. There is no case that I can cite with regards to the specifics. But there are certain cases that note that while acknowledging that there are certain limitations to legislative immunity, that those limitations, they would give examples, and the primary one that I can think of is bribery off the top of my head, and that would certainly constitute a criminal act. And in this particular situation, we would submit that while the General Assembly has provided multiple avenues in which an individual can be pursued for fraudulent claims under the criminal statutes, that none of those give rise to, or the facts as alleged in the amended complaint do not rise to that level or support any of those alleged or any of those bases in the criminal statutes. If it pleases the court, if you have any other questions, I'm happy to address them. Otherwise, I will yield the remainder of my time.
Well, if I could just follow up on what you just said. So is it your position that if in this case, and I know this is not the facts here, but if in this case the allegation was that the mayor had received kickbacks for terminating this contract, so he had gotten financial gain himself personally from his course of actions, are you saying that would be covered still by legislative immunity because there would be criminal sanctions, or are you saying it would not be covered by legislative immunity?
Your Honor, I would respectfully submit that a private individual would not be able to file suit and seek redress against the mayor in his individual capacity for such an action, but it would still subject the mayor to criminal exposure.
Before you sit, though, that raises an issue, and that, for me at least, and that is that do you agree with the town's representative here today that the mayor acting in a capacity as mayor would be cloaked in governmental immunity regardless of any personal liability in a matter such as the one raised by Justice Earls?
I apologize, Justice Morgan. Could you repeat that so that I can?
I'll try.
Thank you.
Your colleague at the table answered a previous question that a governmental act could be fraudulent in nature, but nonetheless, governmental immunity would still apply to the town. Does the mayor embrace that same position?
With regards to the town specifically, or with regards
with regard to the mayor acting in a legislative immunity capacity, although it may be a wrongful act, if it's done as the mayor in that official capacity, then the mayor would be cloaked in legislative immunity?
That's correct, Your Honor. That would be our position.
Thank you.
Thank you.
Thank you, counsel.
Thank you.
Rebuttal.
Thank you. And I don't anticipate using all my time, so I encourage all the questions you may have. Justice Hudson, if I may, you had asked me about the question of, are we just looking at these individual components? And I would cite to the court its prior decision in the estate of Williams, where they go through the factors to be considered. And this is what the court stated then. In the analysis of factors listed above, when considering whether the action of a county or municipality is governmental or proprietary in nature, is particularly important of 2 points we have previously emphasized. And this is where they cite the case of Sides versus Cabarrus Memorial Hospital. First, although an activity may be classified in general as a governmental function, liability in tort may exist as to certain of its phases, and conversely, although classified in general as proprietary, certain phases may be considered governmental. Second, it does not follow that a particular activity will be denoted a governmental function even though previous cases have held identical activity to be such a public necessity that expenditures of funds in connection with it is for a public purpose. And I think that clearly sets out what this court has adopted and set out as its standard going forward, that we do look to that individual agreement. And just so that we could all be on the same page, Mayor Dieter was not in office when the first two agreements were executed. He was not elected to the office. So those agreements were already executed before he even came into office. His fraudulent activity was to undermine those agreements.
Well, to follow up on a question that the Chief Justice asked your
Yes, sir.
colleague, would there be any liability, in your view, on the part of the mayor if the town council had not voted as it voted when it terminated the agreement?
I think there still would be.
So
liability.
how would your client have been harmed if, for example, the mayor had, as a private citizen, gone out without telling anybody, tried to undermine the support for the contract, while perhaps publicly maintaining to the contrary? How could he be liable until the effort succeeded?
Well, and I can appreciate that argument. In every case, you have to have liability and you have to have damages, right? So in this case, the damages component, even if the town did not do it, the mayor still acted in a fraudulent act. And as Justice Earls was speaking about in taking kickbacks, for instance.
Of course, you haven't alleged taking kickbacks. You've just simply alleged, for some reason that apparently consists of, I want to get my hands on the property, at least is the way I understand your complaint. He began prior to being elected, and then after he was elected, attempted to achieve the result to which you object, and that appears to be what the basis for his liability is. My problem, I'm having some trouble understanding how he can be liable in the absence of action by the town council.
Well, it is an interesting question to pose, but in this case, we have the action of the town council. So in a case-by-case analysis, and that's what we've got to do, we've got to look at the facts of the case.
But that's clearly a legislative activity, isn't it?
Pardon me?
The town council's vote is clearly a legislative activity, isn't it?
Yes, but he did not vote.
He was there and presided, but he didn't vote because he didn't have to. There wasn't a tie.
And I'd offer to the court, he was not in a legislative capacity sitting
So
as
he
mayor.
can be held liable for a result in which he didn't even participate in voting on.
Your Honor, the activities that he engaged in order to reduce the amount of the contract price, my clients were to receive up to $1 million for the renovation. He reduced that to $935,000. My clients were supposed to have a memorandum of lease that was supposed to be filed. That would have provided some additional protection. That wasn't filed. Why it wasn't filed, I can make some guesses there, but the activity...
Bottom line is we don't know for purposes of this record.
We don't know, and that's the thing, Your Honor. We're at a 12B6 stage or a 12B2, 12B1 stage. We're not fully into this thing where we've developed the case through depositions, through further discovery. This is still early on. I know it's in 2015, but oh my goodness, it's still early on in the litigation. I would like to address Justice Earl's question about kickbacks. And I know that's not the facts of the case. But in the case that you have discussed, if the mayor was taking, say, donations for his political campaign in order to try to get rid of this firehouse, I don't think that's a fraudulent act in and of itself. The fraudulent act is the mayor actively going out and working to undermine the existing contract with my clients had hope and reliance upon.
Real quickly, why do you need the fraud claim if you've got the contract claim?
They have no home. They're out of existence. They had to sell all of their fire trucks. They are a board. When my client's contract was eliminated, they had to move out of the firehouse, had to sell off their equipment.
Well, if that was done wrongfully, why can't you get recovery with your contract claim?
Because the contract only provides for the liquidated damages of $750. Now, we can move to try to eviscerate the entire contract or rescission of the entire contract, but that's going to go down a long road that certainly under further motion practice. But you can't buy fire trucks, as it's been discussed here today. Fire trucks are very expensive. You can't buy fire trucks with $750,000. Not the amount of trucks that they had, the hoses, the equipment, all of these things had to be get rid of because, and I see I'm out of time. Thank you, Your Honors.
Thank you. Mr. Clerk?